Today is March the 20th, 2017. Updating y'all on Gadsden 6 case. I got my ruling back today from the Alabama Supreme Court. Dated March the 17th, 2017. Case number 11-60318. That's 11-60318. Ex parte Melvin Ray. Petition for writ of cert to the Court of Criminal Appeals. In re Melvin Ray versus State of Alabama from Etowah County. Got the certificate of judgment on my writ. And the writ was denied. No opinion from the court. Says that there is a dissent from Justice Murdoch. I did not receive a copy of the dissent. At the same time I received that order, I received the certificate of final judgment, also from the Alabama Court of Criminal Appeals. And it's also dated for the 17th, March 17th. So, like my dad used to always say, he said, "What? Well, got to get up and try it again." And that's what has to happen, I'm going to sit back and evaluate my options. I can file a writ of cert to the United States Supreme Court. I have to do a little research to see if I can file to the United States District Court, see if I can file a habeas corpus. Or also, I might refile in the circuit court again because I still have this Royal versus State, which is 159 SO3D 731 Alabama Court of Criminal Appeals 2014. That's Royal versus State 159 SO3D 781 Alabama Criminal Appeals 2014. And still have that decision. It's still the controlling law on the issue that I raised. And it still says that the ground that's being raised in my petition states a ground for relief that requires a determination on its merit. Therefore, the case must be remanded to the circuit court again for that court to provide Royal an opportunity to prove his claim, either by conducting an evidentiary hearing and or accepting evidence in the form of affidavits, written interrogatories, or deposition. See Rule 32.98, Alabama Rules of Criminal Procedure. I still not have received an adjudication on the merits on my claims. So technically, because of that and because I'm raising jurisdictional claims, I can go back and file again. Really, it should not be necessary for me to keep filing this petition over and over and over again. The facts are there. These are the case action summaries. Y'all see the date, plain as day. April 27th is the date that the court found probable cause and transferred my cases to the adult court. There is no disputing the fact that I did not receive a transfer hearing. There's no disputing the fact that I was a juvenile. I've already submitted a copy of my birth certificate. So there's no disputing my age. And the law speaks for itself. It says plain and simply that they must have a certification hearing before they can move me from juvenile court to adult court to be tried as an adult. And all of the records show that they did not have any transfer hearing. My mom, she submitted an affidavit. Even the court, I was able to compel them to submit an order to that effect, admitting that there was no record of any transfer hearing. I also have a copy of the court summonses for juvenile court. Y'all can see at the top, juvenile court summons, and you can see the date right there. The date is right there, April 28th. April 28th. And I got all the case action summaries showing that they did not conduct that hearing on April 28th. Instead of conducting the hearing, they just transferred the cases on the 27th, 27th. All these dates, April 27th. And then on April 29th, he filed his certification order. But they never held the hearing that was scheduled on April 28th. So I was unrepresented by counsel, did not receive my day in court. And according to Royal, this is a jurisdictional defect, and it states a claim that requires it to be adjudicated on the merits. I've already shown y'all the orders from the Court of Criminal Appeals, showing that the case was not adjudicated on the merits. I've showed y'all the order from the circuit court showing that they didn't adjudicate it on the merits. The circuit court basically denied it, saying that because I had been previously certified in Madison County, that any future acts no longer was required to be certified. But this is not the law. They didn't cite any law. That's not what the statute says. There's no case law to support it. There's nothing to support it. And in fact, when the Court of Criminal Appeals affirmed the decision from the circuit court, they did not rely on that. They relied on the fact that it is the same claim that had been raised in the previous petition, and therefore it was precluded. And I agree that it is the same claim that was raised in the previous petition, but the standard of review said it must have been raised in the previous petition and adjudicated on the merits. And the claim still has not been adjudicated on the merits even to this day. So that means I've been to the Circuit Court of Etowah County twice. I've been to the Alabama Court of Criminal Appeals twice. And I've been to the Alabama Supreme Court twice. And the law still has not been complied with in my case. I still have not received an adjudication on the merits. And on this second go-round, they're denying me relief because they're saying it's the same claim that was raised in the previous petition. But as I showed y'all, in the Royal decision, this was also the same claim previously raised in one of his petitions. In fact, the court says on March 14th, the circuit court complied with our instructions and filed a supplemental record, which indicates a prior petition Royal had filed in 2006 in which he argued the same claim he raises in the petition. That's what it says right there. That's what it said. That's what this part right here says, what I just read. In his case, even though it was the same claim, they said that because it's a claim that state a ground for relief that requires a determination on the merits, they sent it back. And I showed y'all in my appeal that they just said it was the same claim, but they did not hold that it had been previously adjudicated on the merits. And the reason why they didn't hold that because it has not been. So it's unfortunate. Those are the circumstances. And so I have no choice. The choice was made for me. I didn't choose to want to file again. That choice was made for me. This time I'm hoping that I'm able to secure assistance from counsel and see what type of advice I can get from an attorney. Let me pause this 1 second. Okay, I had to pause for a second because I wanted to get these statutes because these are the old statutes. They've since revised these statutes and they're numbered differently. But as you know, it's the law that was in effect at the time that I was prosecuted that they have to go by. And at the time, it was the Alabama Juvenile Justice Act, and it was 12-1534, subsections A and B, A, B, C, D, E, and F, as a matter of fact. And these are the sections of the title that made the conducting of a transfer hearing mandatory. This is before the automatic transfer statute was implemented in '96. My priors occurred in 1988. And in 1988, it was mandatory that they have these transfer hearings. And so I wanted to make sure I add that too, so that whoever is watching, when I seek legal assistance, they'll know the statute involved, 12-15-34, transfer of cases from juvenile court to criminal court, and understand the issues being involved is that I was transferred to adult court without a transfer hearing. Transfer hearing was set for the 28th, and the judge did not conduct that hearing. Also, there is a Supreme Court case, which is really the controlling case, which is Kent versus U.S. and it's 383 U.S. 541, and that decision was issued in 1966. And the Supreme Court said at that time that there are too many fundamental and substantial rights that are in effect for a child for them to transfer without ceremony. And they said that the hearing is mandatory. And so with that being said, the fact that no hearing was conducted in my case, there's no reason why I should continue to have to keep filing over and over and over and over when the record is clear. Like I said, the last time my petition was denied, it was denied on the ground that the judge said that because I had been previously certified in another jurisdiction in another county, which is true, but that's not what the law says. It says, in fact, under the new statute, under the new Juvenile Justice Act, you can find specific clarity under Title 12, 15, 203, subsection I. It will show you that even though I have been previously certified, I have to be either convicted or I have to be adjudicated a youthful offender before they no longer have to certify me as a juvenile each time. I had not been convicted for those crimes, and I had not been adjudicated youthful offender status. I got a copy of the cases that they were relying on. Like I said, I had been certified, but I do have the cases here and the copies, and this one shows that I was not convicted until October 5th of 1988. That's the date on that one, October 5th, right there, 1988. You can see that youthful offender status was not denied until September of 1988. Right there, September 26, 1988, youthful offender denied. So I had not been convicted on April 27, 1988. I had not been granted youthful offender status on April 27, 1988. In the case that I had been previously certified on. And this is the other case that I had previously been certified on. I had been previously certified on this case, and I was not adjudicated until January 23rd of 1989. So these are the two cases that the judge in the circuit court correctly ruled that I had been previously certified. But the law says that I must have been previously certified and convicted or adjudicated youthful offender. If I had been adjudicated youthful offender or convicted of either one of these when I appeared in the Gadsden court, then the court would be correct. But because I had not been convicted, because I had not been adjudicated youthful offender, then the court was still required to conduct a transfer hearing. Because I was still a child. I was still only 16 years old, and these were nonviolent property crime felonies. These were not serious offenses. There was really no reason for them to certify me on these cases. But they did anyway, because they then took these felonies and they had them poised to use against me. And that's what they did. They used these felonies to enhance my current sentence under habitual offender law to give me life without parole. And without these felonies, I would not have life without parole. So now that I have the proof that these felonies are invalid and that the sentence that I'm serving, the life without parole sentence, is illegal, they don't want to grant me the relief that I'm entitled to. They don't want to adjudicate my claim on the merits. But that's not fair. That is totally unfair. It's a total denial of due process. It has me serving an excessive sentence. It's cruel and unusual punishment that I'm serving life without parole, where they're using illegal evidence to impose that sentence. So I'm serving an illegal sentence, and I'm fighting against that. So I got all my documents, anything turning these. I got the case action summaries. I got my birth certificate. I got this order from the court. There is no disputing the fact that I didn't have a transfer here. There's no disputing that. I did not have an attorney. I was not represented by counsel at this critical stage, and it is a critical stage. In the Kent case, the U.S. Supreme Court determined that it is a critical stage. This is an order that I was able to obtain in Etowah County on May the 13th, 2008. It was submitted by Judge William H. Reed, Circuit Judge, in case number CV07-773.60. And it says, I read, the undersigned has been advised that there is no record transcript of any proceedings that occurred on April 28th concerning a juvenile certification hearing. There's no record because it never occurred. And so, gotta follow my dad's advice again. Gotta get up and keep trying until this illegal sentence is taken off of me. And these illegal priors are vacated and void. Like Royale said, they should be. Other case law, that someone wants to review this and verify my claim. Get these couple of cases, and then I'm gonna be out of here, because as you can see, I got work to do. I got some work to do, fighting for my freedom. I'm a freedom fighter. I want my freedom. Let's see what we got here. DH versus state. DH versus state. 24 SO3D 1166, Alabama Criminal Appeals 2009. DH, D is in dog, H is in house. Let's see, where is it? I'm gonna get you to look at it right there. That's one of them. Another one of the controlling cases on that issue. Ex parte Ward 540 SO2D 1350. This is case law. Let's see. Right here. Sorry. Ex parte Ward. Can you see that? Ex parte Ward 540 SO2D 1350. So that's another one of the controlling cases on that point of law. That one, of course, is out of the Alabama Supreme Court. This will be the statute involved. Right here. That's the statute involved. Code of Alabama 1935. 12-15-34. That statute is no longer in existence. It has been renumbered, and it is renumbered as this statute. 12-15-203 subsection I. And that is the statute that says And this is how it starts. A conviction or adjudication as a youthful offender of a child of a criminal offense, with the exception of traffic petition, shall terminate the jurisdiction of a juvenile court over that child with respect to any future delinquent acts and with respect to any pending allegations of delinquency. So the fact that it says with respect to any pending allegations proves that the cases that you can be convicted on or adjudicated can be in one jurisdiction, and it says, and any pending allegations of delinquency can be in another jurisdiction. So that statute even shows clearly that two courts can exercise jurisdiction. The circuit court can exercise jurisdiction under the cases that have already been certified, and the juvenile court can exercise jurisdiction over any pending allegations of delinquency, which have not been disposed of by the juvenile court at the time of the criminal conviction or adjudication as a youthful offender. So, and that's what we have here. You know what I'm saying? And it says it shall terminate the jurisdiction over that child to any future delinquent act. So when I caught these original delinquent acts in Madison County, the fact that I caught them did not terminate the juvenile court's jurisdiction with respect to any future delinquent acts. It did not. The only thing that would terminate future delinquent acts would be a conviction or adjudication as a youthful offender of these. And so that's what's on the plate as far as this goes. And like I said, I'm gonna be sending this video out to attorneys around the state, legal clinics around the country, hoping that someone, an Eighth Amendment attorney with experience in criminal law and juvenile rights will get involved and help me prosecute these cases, these illegal cases that they're using to enhance my current sentence as a habitual offender. And they've given me life without parole based on these priors, and I should not be serving life without parole because, like I just showed you all, these priors are invalid and void because the circuit court did not properly acquire subject matter jurisdiction because the juvenile court did not hold a mandatory transfer hearing, which is a jurisdictional requirement. And that's what Royal states, DH states, ex parte ward, on and on and on. That is the law in the state, that the transfer hearing is a jurisdictional event. That is how the court waives its jurisdiction. It cannot waive its jurisdiction outside of a hearing for these offenses. And that's the law. That's not me talking. That's what the statutes say, and that's what the opinions that have interpreted those statutes say. And so I'm looking for that to be applied in my case. And I'm looking for my day in court, which Royal says that I'm entitled to, so that my case can be determined on the merits. And that's advocacy for the Gadsden 6, 2 of us. These priors were used to enhance 2 of our cases, to give us life without parole. Both of us are actively fighting to invalidate these priors and get this life without parole death sentence off of us.